Matthew from Redirect Immigration Law Podcast. Today we spoke with Ron Abramson, and one thing that we mentioned, and I think that we should have really expanded on, was Trump's decision or presidential proclamation affecting the ability to seek asylum for certain people who enter the country unlawfully. The proclamation basically says that anyone on the southern border who enters the U.S. unlawfully, meaning over the border without going through a port of entry, would be ineligible for asylum. And we just touched on it, and I mentioned that it goes against the actual clear statute. The statute is Immigration Nationality Act, INA, Section 208, which says that anyone who is present in the United States can apply for asylum. People unlawfully crossing the border on the southern border have traditionally been eligible to apply for asylum because they're considered anyone. They're just here in the United States. And so President Trump is trying to change that, not by Congress, but by his own proclamation, which can be obviously problematic. Remember, Republicans were very up in arms about DACA and DAPA because the president didn't go through Congress. Here, let's see how they react to this proclamation. My sense is that Republicans will be all for it. We'll see what the court says. So how does this affect people who enter the United States unlawfully over the southern border now? Traditionally, if you enter over the southern border or anywhere in the United States unlawfully, and you're encountered by Customs and Border Patrol, they'll detain you. If you express a fear of return, well, the first thing they'll do is they'll give you an expedited order of removal, and that will subject you to mandatory detention and expeditedly being removed from the United States. However, if you express a fear at this juncture, they'll set you up for what they call a credible fear interview. And if you pass that credible fear interview, then you'll be placed in regular removal proceedings and you can seek a bond. What will happen now if this allows to stand, which court challenges have already been brought, and I don't think it will survive a court challenge, but if it did, then someone in that same exact situation would have the expedited order removal tag placed upon them. If they expressed a fear, they would have what they call reasonable fear interview, which is a higher scrutiny than a credible fear interview, and they would only be eligible to apply for withholding of removal and protection under the Convention Against Torture, and that expedited removal, that removal order would stay in effect on them. And the practical difference is that it's a higher standard to meet. Withholding a removal is a higher standard than just plain asylum. Benefits are different. If you receive asylum, in a year you can apply for your permanent residency as derivative status, so your children would be able to benefit, any spouse would be able to benefit. Withholding doesn't have those same protections. But one of the practical differences is, and I don't know if we really have a clear answer, is people that would only be within withholding only, who have that only a reasonable fear interview, if they pass, it appears to me from my looking at it that they wouldn't be eligible for a bond, which means that we'd have a lot more people in detention on our southern border, which I think is probably, honestly, the point. It will increase detentions down there. These private companies have to go and they make these, Trump says that he's going to make these big tent cities. So, and they're all going to be done by for-profit institutions. So I just want a little explainer, not too detailed, about what we were talking about when we were talking about with Ron about this presidential proclamation. And again, there's actually a statute clearly on point that Trump is basically trying to get rid of with this executive order. I don't think it would stand up, but we'll find out. Thank you.